documenting our different events, always showing up to court, always advocating for our people, always supporting our people behind bars and families out here. And so Muti is going to speak about his experience, his work, and this time bar.
And always tie it into everything that's been said. Nate said a lot, and Sister Shamika said a lot, as well as you. I could piggyback. We don't have the time to really delve into all of it, but I'm going to try to tie it all in. I want to thank the family members and folks for coming out, because this is really what it's about. This is how you build foundation. This is how you solve the problems. You get knowledge, you get information, you move, and water seeks its own level. You connect with people of like minds in certain circumstances, and that's how you strengthen, and that's how you get things done. If you can get things done as an individual, you meet two other people, y'all can get it done 3 times quicker, and so forth and so on. So I want to thank y'all for coming out. You know, prayerfully, when we leave here, y'all gonna leave much more educated, much more inspired, based on the things that we have already accomplished in being in circumstances that's totally, sometimes ungodly, odds that's just insurmountable, so allegedly, and we still surmount those odds. So prayerfully, that's why we're here, and that's why we do what we do. If I can go back to the first thing you said, Sister Shamika, you're right. In terms of learning the law, that's definitely a must. My folks primarily came through my sister. The others were just hanger-ons. They spent in excess over $260,000, and that's a rough estimate. And just fighting my situation, and just dealing with lawyers, and that's why I had to coin a new phrase, and that's another thing. I created a lexicon and language to aptly describe the crimes that's being committed against our people in court every day. They don't have a word for it, or words. So I had to create the words. And one of the words I created is closet prosecutor. Most lawyers in the state of Pennsylvania, particularly in Philadelphia, they operate as closet prosecutors. They work in lockstep with the prosecution to get the conviction, and they work in lockstep once you're convicted to maintain the prosecution through appeals. And the receipts is ample. It's just crazy. So that's number one. And so you're on the right path, and your son coming home. Just got to put the work in. If I know, first of all, I didn't tell you that I was prosecuted as a child at 17, and it took 42 years to win my exoneration. And if I knew then what I know now, I probably would have been out in 18 months. But to keep it all the way funky with you, I wouldn't have appreciated it. You know what I'm saying? I still would have been hanging with the wrong people, you know what I'm saying? And would have found myself right back in that situation. You know what I mean? So, but my story is not unique, only in that when I was so going to what Nate was talking about, creativity, I add something to that. He was so correct when he said there is an actual time bar, legally speaking, but in fact, there's no such thing as a time bar. When you're creative and you're, I can't think of the other word, but there's 2 words. Oh, your creativity and your imagination. If your creativity and your imagination are unlimited, so too is your litigation. And there's nothing you can't win. Nothing. With creativity and imagination, if that is unlimited, can't nothing hold you. Nothing. I don't care what it is. And I always simplify it like this. The sentence they gave your son is the sentence they gave me. As a child, death by imprisonment, to die in prison. What's the sentence? I'm a writer. You just rewrite the sentence. That's all you got to do. Rewrite the sentence and then impose that sentence on the court. You know, it's that simple. It's simple to do once you rewrite it, but the work comes in imposing that sentence on the court. And Nate was talking about when he held up the paper. That's why I love coming to these joints. It's like he just walked me down memory lane when he held up the paper. When I filed my writ of habeas corpus dealing with post-conviction and the so-called Anti-Terrorist and Effective Death Penalty Act and the unlawful that's another thing. The Pennsylvania post-conviction is unconstitutional. That's number one. But in filing, when I got to federal court, and many of the things that he talked about, they threw that in my face. And one of the things that I realized, because I was self-representation, you would put your court order on your petition, and I was in solitary confinement, so everything I wrote was by hand. And so when I get the joint back from the court, I open it up. It's a court order, but it's written in my handwriting. I said, "What?" I said, "This ain't real." And I said, "Oh, this is mine." And at the bottom of the joint it says "granted." And I'm like, "Damn, I can literally write myself out of this joint." And that's all it was about, like having those moments of clarity to push you forward. My writ of habeas corpus, federal writ of habeas corpus, was like 130 pages long, which is absurd. Should only been like maybe 17, 18 pages. But for me, I'm not going, if I die in here, my posterity going to know that, yeah, he fought. He wasn't nothing nice. You know what I'm saying? But I knew that I was going to be free. It wasn't a matter of if, it was only when. And so I knew if I stayed on that track. And then mastering post-conviction is what we're here to talk about. We realized that. Now, the main thing that he has to deal with is the subsection 9545B, Roman numeral 1, which is 1, 2, and 3. Now, here's the thing. This is the beautiful thing about dealing with somebody who done went through that road. The first one deals with governmental interference. The second one is newly discovered facts. The Pennsylvania Supreme Court has admitted the way that they was interpreting that was incorrect. They was calling it newly discovered evidence. And the Superior Court was using the standard, which is very high for newly discovered evidence. But then they folks put in prison, put together these brilliant arguments, and they said, damn, they right. This is not what the statute says. The statute says newly discovered facts, and the bar for that is way down here. So now, before we had to climb the fence to prove, now when you go by the statute, using what they call statutory construction, it's only down here. So therefore, it's just a hop, skip, and a jump now. It still worked, but it's a hop, skip, and a jump now. And in that opinion, they said that what did they say? We erred, or was it erroneous, or we misspoke, or something they said. But they admitted they was wrong. So that's not impossible to admit that they're wrong. And so once we got them to do, and then the third one is, unless the United States Supreme Court or Pennsylvania Supreme Court comes with a new law and rules that it's retroactive. But even that's bogus, because if you look at the line of cases in the child cases, and we talking about maybe 25 years, starting with Virginia versus Akins, starting with Virginia versus Akins, and then you come up, it's like 15 different cases. And each of those cases, none of those cases talked about retroactivity, but we know that we wound up having to go to court because in these opinions, they never say that something is retroactive and it's still applicable, but they'll tell you, no, the court didn't say that it was retroactive. And then once they wrote the opinion, they said, no, it's not necessary. And then they went into some factors that we didn't know anything about, where they never have to actually use the word retroactivity and it's still retroactively applicable. So those are the things that you begin to learn as you get in that fight and study like you're talking about, and you're going to get these victories. The only thing that I would say is make sure your son matches your energy. You can't be carrying the load. You know what I'm saying? Everything you do, he got to do you times 2. You know what I mean? He has to do the heavy lifting. You just do the footwork because his feet is tied. Then, later on, if y'all come back, we'll talk about that as well.
Danforth versus Minnesota was the case you said that all cases rendered by the Supreme Court, Supreme Court, or United States Supreme Court be deemed retroactive.
Yes, that's it. That's what I'm talking about. That's why it works to be in the room with litigators. You know what I mean? Also, too, in that case, what it pulled my mind to, just this is not off topic, but it's on topic. In Danforth, I discovered a case in Danforth that said, this was just mind-blowing, but it's something we know to be true because we litigators. It talked about how, and it was a California case, and in the California case, the court, the California Supreme Court admit that these dudes was being done dirty. And the thing was, the prosecutors was booking them based on post-arrest silence. In the closing of the argument, the prosecutor would say, and the defendant sat here and didn't say a word. That's a violation of their right to remain silent. And so the California Supreme Court was like, yo, if we admit, we done this to damn near everybody. If we admit this, we're going to go broke. And the Supreme Court agreed with that bull crap. They didn't say that the people wasn't unjustly dealt with. They just said that cost too much money. And the language that they use, again, they codify white supremacy in language. The language they use was for judicial economy. It's a fancy word to say that costs too much money. You know, so justice costs too much money. We put you in prison spending all this money. Then when we realize we done wrong, it don't even take that much money to get you out. But they fighting so hard to validate the system and its injustice. So it costs more money because really it costs a lot less to let you out than it do to put you in.
Yes, it does. But they owe a lot more than just